Well, good evening, everyone, and welcome to New Space Chicago. Thanks for coming this evening. We are, as mentioned at the introductory video, we are a nonprofit organization dedicated to nurturing the new space industry in Chicago and helping encourage space startups in the Chicagoland area. We are excited this evening to have a presentation with Charles Mudd, founder and principal of Mudd Law Offices. Over the last 16 years, Mr. Mudd has developed a broad-based practice representing local, national, and international clientele in diverse litigation and transactional matters, with offices in Chicago, Houston, and Park City. And he's become internationally known on issues of technology, intellectual property, and the internet. Over the last year or so, Charles has positioned his firm and practice at the forefront of space law and the expanding commercial space industry. So I'm very excited to have Charles present this evening on the coming satellite regulatory regime. So Charles, I turn it over to you. Oh, and I should mention there is a Q&A channel. So if you want to submit your questions there, then Charles will be able to answer them.
Thank you, Dave. Screen okay, and I'm gonna just adjust the camera. All right, so thank you, Dave, and welcome everybody. I'm happy to talk again at New Space Chicago. I know that you'll hear this later, but I just want to put a plug in for the Student Space Congress that is coming up at the end of the month. So if you haven't already, please register, pass the word. We're happy to talk with everybody and have everybody join, students, professionals, industry, academia, and so forth. Today, I'm going to talk about looking forward into the satellite regulatory regime. I really had a great conversation with a lot of you ahead of time or before we started here. And for those that I didn't, I'm happy to take questions during or afterwards. So please use the Q&A function. Happy to have a conversation and talk about space law. As Dave mentioned, I'm the principal of Mudd Law, and we have offices in Chicago, Houston, and Park City. Feel free to subscribe to our newsletters at muddlaw.com so that you can keep up to date on what's going on. So what is space law? You know, we had a conversation in just a few minutes ago, and I was going on about how space law has been with us really for as long as we have looked to do something in space. So as long, you know, going back to when the government started to contract with certain manufacturers building space products such as missiles or the Saturn V or Gemini parts and so forth. Space law has been around for a long time, and certainly international components began as soon as Sputnik flew across the sky, if not before. But what is space law? Great, Charles. It's been around for 70 years. What is it? Well, I would argue that there's, at the pinnacle, there's international space law. So treaties govern, here in the United States at least, treaties are the highest point. And that's the basis of our legal system anyways, that the treaties that the United States enters into is at the top of the pyramid in terms of what controls our laws. Then below that, the Constitution, federal statutes and regulations, and then state. So we have international space law, then we have domestic space law. And those are laws that are specifically focused on non-terrestrial matters or space. We have nuanced laws, I call it a subset of the regulatory regime, laws that may not appear related to the space industry, but do happen to be associated with it. Then we have the regulatory regime, which encompasses a lot, and we'll get into that today. And then you have traditional law. So, you know, contract law still applies to space law. There's an aspect of that. Intellectual property is still, related to space law, but that's not what we're going to talk about today. Rather, we're going to talk about the regulatory regime. So the outline of my presentation is going to be a little bit of background, talking about international law, try to hit the U.S. regulatory regime, dive into the orbital debris proposed rules, the request for comment that was issued, talk about some other agencies, and we'll see how far we get in the time that we have. And I have my phone up, so if there's any technical issues for those that were here before in February, please let me know. But hopefully everything's going good. We're going to have a great presentation. And again, I encourage dialogue. And let me just flip over here so that I can see the Q&A if anybody asks that. And I think I'm ready to go and off to the races and talking about specifically the regulatory regime. So what are some space-related agencies? NASA. We had a big day this week, right? How many of you saw that the rotorcraft on Mars? That was fantastic, amazing, and just awe-inspiring. We have NOAA. We have the FAA. We also have the FCC. These are the four probably that most people consider related to space. Perhaps not so much NOAA, but it is a key aspect, a key agency in that regard, particularly in relation to Earth sensing satellites that look toward Earth, particularly the Department of Commercial, Remote Sensing, and Regulatory Affairs, the CRSRA of the NOAA. The federal government, if not the state governments, love their acronyms. So NOAA is within the Department of Commerce, and the specific part of NOAA that's most related to space is the CRSRA. That provides, this is kind of the general aspect of that no person who's subject to the jurisdiction or control of the U.S. may operate any private remote sensing space system without a license. This act also authorizes the Secretary of Commerce to license private sector parties to operate these remote sensing space systems. So this is language from or based on the National and Commercial Space Programs Act that not only prohibits the use of remote sensing of Earth unless you have a license, but gives the Secretary of Commerce, the Department of Commerce, the authority through NOAA, the CRSRA, to license those devices. So it provides for licenses, also annual audits that you would have to complete to make sure that you remained in regulatory compliance. Quarterly audits, you'd have a quarterly audit with lots of instructions and paperwork. A lot of it's electronic at this point. But we also need to remember data protection. Data protection is key in the space industry among any other industries. I know some of you probably deal with data protection, data security, cyber security on a regular basis. No different in the space realm. And in fact, it's a significant component of concern at highest the United Nations, here in NASA and other areas. So this is just an example where, and so specifically related to NOAA, one of the things is to make sure that you have a data protection scheme, and they actually have a data protection template that you can use in reaching that obligation. But even within the CRSRA, there exists coordination between the Department of State, Department of Defense, the Interior, JCS, and the Office of the Director of National Intelligence. So even though you may apply for the license through NOAA, your application actually is routed into a number of different areas. All of these agencies deal with intelligence, the aspects of Earth observation, and so forth. So you need to be keeping aware of all that, or better yet, have an attorney that helps you hire an attorney to keep you abreast of the changes. And recently, NOAA's regulations in this regard were updated as recently as May 2020. Now, we also have the FAA within the DOT, which is the Department of Transportation. Most people think about the FAA in terms of our commercial air flight, regulating our commercial air flight, even regular private flight. The FAA controls the airspace. And so where does it really come into play with respect to space? We have the Office of Commercial Space Transportation, the enabling statutes, the Commercial Space Launch Act of 1984, and the amendments in 2004. Clearly, they were governing this before, but currently these are the statutes at issue. And they focus on a number of things. Within the statute and the enabling regulations, they focus on the launch or re-entry of vehicles, regulating and licensing launch sites and launches, experimental permits for reusable suborbital rockets, safety approvals. So within, and even within the launch or re-entry vehicles, regulating that, there's the pre-application consultation that the OCST has, and then you need to go through a policy review and approval to get that particular launch license. Within the safety review and approval, there's also the payload review and determination. So there's a number of aspects that you need to be thinking about when you apply through the FAA for a particular launch license for your launch station or launch vehicle. Financial responsibility. There is an environmental review. We'll come back to this particular issue with the FCC. And of course, there's compliance monitoring. Now, if you have an interest, you can always look to see what are the current spaceport site licenses or the launch licenses that have been given out by the FAA. Very interesting to look at, and even more interesting from my perspective, perhaps not yours, the actual text of the licenses. So for example, on the left, we have a license to Orbital Sciences Corporation. On the right, the license or a license to Space Exploration Technologies, which you more likely have heard referred to as SpaceX, which is their primary brand. They also do within the OCST experimental permits, safety approvals, balloons, anything that flies into the orbital space. The FAA is going to get involved. Drones, kites, amateur rockets, etc. There are regulations for everything, as you can imagine. The new launch and re-entry regulations actually became effective March 10th of 2021. And then there are certain aspects that are going to be 2026, and that's relating to the information collection requirements. Before we get to the FCC, I want to focus on an agency or a couple agencies and a couple sets of regulations that are all too important, but often overlooked or not even thought of by those venturing into the space industry. That is the Department of State and ITAR, and the Department of Commerce and EAR. ITAR is the International Traffic in Arms Regulations. EAR's the Export Administrative Regulations. You might say, Charles, I'm not going to be launching missiles. What am I needing to deal with? ITAR, the munitions list. I'm just telling you it's much broader than you would imagine, and we can circle back another time. But there's not enough time to go into the depths, and we actually have a new space presentation where I did go into the depths of ITAR and EAR previously. So happy to talk about that. That's not the focus here, but it really is much more broad than your munitions list. The munitions list sounds like military and so forth, and that's what one would think of, but it's much broader than you might think. And ITAR and EAR focuses not only on the technology, but the information. If you're sharing information and technology from one U.S. citizen to another, probably not a problem whatsoever. But as soon as you start to share that information or that technology that falls within ITAR or EAR to a non-U.S. citizen, you run into issues. So be careful. Let's move on to the next category. What is orbital or space debris? That's one of the things that I want to talk about here today in the regulatory context to just show how in-depth things can get and what the status is. Because the last 2 years, I've shown how the NOAA regulations, NOAA space regulations have been updated, FAA regulations have been updated, And now the FCC regulations relating to satellites, and particularly on orbital debris, are in the process of being updated. Some became effective last year. Others are still waiting for the final rules. So what is orbital debris or space debris? Why care? I just want to say two words: the Kessler syndrome. If you go home tonight and you don't remember anything other than two words, Kessler syndrome, and my email address, and then you can email me to hear more about it. But the Kessler syndrome is basically talking about a situation where there will be so many objects in space and so much debris in space that we'll get to a point of cascading effects, meaning that the objects will start to collide with one another, creating more debris that collides again, and a cascading effect to where we are orbital space, the orbital space of Earth becomes very congested if it's not already congested. According to NASA's study of large constellations, if we fail to start deorbiting satellites that have completed their missions within a more reasonable time frame, the likelihood of catastrophic collisions will grow. Sounds pretty straightforward to me, and I think it's true. Do you know what the current regulation is on end-of-life deorbiting of satellites? A lot of those in low Earth orbit are going to degrade in their orbit and burn up within that time frame anyway. 25 years. So you've got the end of mission, end of life. So between it's being used to the point that it's destroyed, 25 years. That's a long time. Here's a chart that just kind of gives you an observation or perspective on the number of objects in Earth orbit by type. So we have the total object going up to about 2020, middle of 20, maybe 2019 in this chart. The fragmentation debris of the subset is obviously more. You have spacecraft, mission-related debris, rocket bodies. I don't know. I'm trying to remember the app that I have that I use for finding stars and so forth in the night sky, kind of an AR aspect. But in addition, you can see rocket bodies as well. Interesting, kind of scary as well. So here's another kind of perspective, the altitude distribution of detected objects. We can see that most of the congestion occurs within the orbit of 600 to 1,200 kilometers. Now, what's another way of looking at all of this? Though impressive, 2D, talking about charts, doesn't really fully present the issue. So let's look at a 3D model over time. And I will just play this for you briefly to kind of give a perspective on the number of cataloged objects over a period of time. So we're starting at 10 greater than 10 centimeters in diameter, showing the number of objects as they increase over time. So a lot of this obviously is debris in the truest sense, but debris also encompasses any satellites that have reached into mission. So past that mission lifetime, where they're no longer functional, no longer being used, are really considered to be debris or space debris or orbital debris as well. So we kind of here get a perspective. There are a lot of cataloged objects, and it becomes more and more congested as time goes by. And if we look at things from a smaller perspective, we can begin to see, now one of the law students that I should have recognized that photograph there. So this is the same thing that we saw. Let's move on. Let's look at a fly-through. How about that? We can get a little bit more perspective on the amount of objects that we have in Earth's orbit. And it just kind of drives home the point is why, we've got the Kessler syndrome, a lot of people talking about orbital debris being an issue, that we need to talk about that, but getting a full visualization of Earth. Now, granted, Earth is big and the orbital space around Earth is big, but looking at it from this perspective, it's not as clean as it once was, right? You can spend more time looking at the video. I recommend it. There's one final kind of presentation that I want to see through the ESA. It just, again, gives us another perspective here of looking at matters to really kind of get a presentation. The visual may or may not, it doesn't look that bad. It's a little bit worse on my screen over here. But again, it's kind of giving a perspective of the debris that we have cataloged. It started off, I think, greater than 1 meter, and we'll see the congestion just continue to increase as we move along. So the question is, how do we deal with this? There's a whole regulatory history of dealing with space or orbital debris. And just as an aside, it's basically one and the same thing. Orbital debris is the term preferred by the United States, and space debris is preferred elsewhere. This is greater than 10 centimeters. And so when we started to look at this issue, the United Nations started to take a look at it, and then certain countries came together and formed an interagency debris coalition, more or less, or commission, the IADC, focused on trying to reach some consensus of guidelines. Now, the United States, as well, as I'll get into in just a moment, started to look at this issue some nearly 30 years ago. So it's not been a new issue. It's certainly not been something that's come up in the last few years. But to give you perspective, to give you a little perspective, up until about a year ago, or let's say May 2019, when it wasn't the first Starlink launch. The first Starlink launch was 1 or 2 of the Starlinks, but the first launch of like 60 Starlink satellites at one time was May of 2019. At about that time, we had about 5,500 satellites orbiting Earth. Of those, about 2,500, 2,750, 3,000, somewhere in there, were the functional satellites. So you think about that, all right, 2 years ago, we were at top maybe 6,000 satellites, maybe a third of them were non-functional. SpaceX has a license for more than 40,000. OneWeb had, and now it's been assumed, had a license for 40,000. There are estimated to be 40,000 launched in just a short in a 10-year period. So the amount of satellites going to be up into space and the amount of debris are certainly going to increase as we move along. So returning to mere numbers, the small objects are serious. Paint flecks impacted the space shuttle, and the ISS suffered an impact requiring a finger to initially plug the resulting leak. And in fact, the Hubble Space Telescope has also experienced debris collisions. So it's not just a matter of satellites colliding with one another, it's even the small objects that we really need to be aware of and focused on. As I mentioned, there's the Interagency Space Debris Coordination Committee. I was wrong. I said coalition and then commission, coordination committee. So the IADC, they started looking at about this in the early 1990s, and we had in October of 93, the first terms of reference were established by the 4 founding members, NASA, the RKA, Japan, and ESA. The primary purposes of the IADC were to exchange information on space debris research activities between the member space agencies, to facilitate opportunities for cooperation in space debris research, and review the progress of ongoing cooperative activities and debris mitigation options. So what is space debris? I mentioned it before, but here's a definition. All man-made objects, including fragments and elements thereof, in Earth orbit or re-entering the atmosphere that are non-functional. So again, as I mentioned, as soon as a satellite becomes non-functional, as long as it's still, whether it's wholly together or apart or collided with something or broken up, it's space debris. The main IADC guidelines included, or the main IADC documents included guidelines, a support to the guidelines, a statement on large constellations, and a protection manual. The essential guidelines are that each mission, program, or project should have a space debris mitigation plan that addresses space debris mitigation activities, assessment and mitigation of the risks relating to this, including standards, measures that's set up to measure minimizing hazards with malfunctions that could create space debris. So essentially, what are the contingency plans? How do we address situations where our object, our launch vehicle, or our satellite orbiting object runs into a problem? Sometimes it might be the fuel on board that explodes, causes an explosion, and creates that debris. Disposal of the spacecraft and/or orbital stages at end of mission or end of life. The justification for the choices made, and to look through the compliance matrix as to the guidelines. The common principles were to limit objects released during normal operations. Now, in the parentheses here, this relates to the correlating United Nations guidelines. Limit objects, number one, limit objects released during normal operations. Prevent on-orbit breakups, that makes sense. Remove spacecraft and orbital stages that reach end of life from operational orbits, and prevent on-orbit collisions. All very straightforward. I recommend that you dive into that if you're interested in this particular issue. Great weekend reading. The summer's coming up. Beachside, whether beachside it's or in your office. Great reading. So as I mentioned, the IADC had corollary regulations or guidelines with the United Nations. The main organizations related to space in the United Nations are the pair. They're interrelated. They're not separate organizations, but UNUSA and COPIUS. UNUSA is the United Nations Office for Outer Space Affairs, and COPIUS is the Committee on the Peaceful Uses for Outer Space. I recommend that if you are interested, that you take a look at UNUSA's website. There's a lot of information, a lot of great things going on. Here even it talks about space applications to fight coronavirus. I was fortunate enough to attend three space conferences through UNUSA. The two were in person, first in Moscow. The second space conference or conference on space law and policy was in Istanbul. And most recently, they had the Dark and Quiet Skies conference that was virtual. We'll get to that a little bit later. So the UN Space Debris Mitigation Guidelines represent voluntary guidelines that emerge after a 13-year process. We had 1993 with IADC, UNUSA picked up in about 1994 and continued through 2007. You'll see that that length of time is not an anomaly in terms of trying to address some of these issues. And I think that as the space industry grows, we don't have the time and luxury to wait for regulations to take that long to develop. Now, the UN guidelines emerge from the IADC guidelines with consideration of the UN treaties and the principles on the uses of outer space. As an aside with the treaties, there are 5 major United Nations treaties. The United States is a signatory or compliant in 4 of the 5. The Moon Agreement, the latter one, is the one that we have not signed on to, and probably won't, given that we've enacted a law completely contrary to some of its tenets. But the last UN International Space Treaty focused on space was the Moon Agreement, and it became effective back in the early 80s. So we've got a situation where 40 years have passed since the last United Nations Space Treaty. The definition under the United Nations space debris, their space debris definition really mimics that of the IADC. So we're not going to get into the similar objectives to other United Nations sectors. So I definitely, there are corollary agencies. They're definitely related in terms of the guidelines. I recommend looking at both. Within the United States, we've got the Federal Communications Commission that has taken a look at orbital debris. Now, before we do that, why should any particular country feel or be concerned about regulating debris? Well, we really don't want commercial operations, or we really don't want countries doing this, intentionally sending up ASATs or anti-satellite capabilities, right? Where this was a test by the Indian government to knock out one of its own satellites, but you can see that significant visual representation of exactly what happened when they collided. There ended up being two specific debris fields going each way, right? The laws of momentum. And the initial reaction was, no, it's not going to be a problem and don't worry about it. But there was a significant concern that some of the debris objects could reach into the orbit and affect potentially the ISS and other objects. You see, the debris, it might be hard on your screen, but the debris field is as high as up here and beyond, and at those particular angles, they'd be expanding beyond that. So that is why we need to think about having regulations beyond just guidelines. The United Nations are just guidelines. Without a treaty that we sign on to, they are just guidelines. IADC, just guidelines. So within the United States, how do we regulate this? How do we address this? Well, we look at the FCC. And I'm not going to get the entire backstory here, where this began with the White House, the Clinton White House in the early 90s, about the same time as the United Nations and IADC. There were some studies going back and forth, but the current regulations that we're talking about, the changes, really began in 2004. It was docket number 0254, which really means 2002, but that was basically where we obtained the second report in order in 2004, but nothing really happened. Not until 2018 did we get a notice of proposed rulemaking, an order on reconsideration, and the docket, the 0254 docket, was terminated in favor of the 18313. And so, as I'm going to show in some documents here coming up, if you're searching for it, it's the docket number 18313 is the one to search for. April 24th, the FCC issued updated satellite orbital debris mitigation rules. It indicated that a further notice of proposed rulemaking would be forthcoming. July 13th, it sought comments on information collection, and in August of last year, it did issue the further notice of proposed rulemaking, where the comments were due October 9th and reply comments were due November 8th. Before diving into some of the specific updated rules, interested parties will need to obtain NASA debris assessment software or the equivalent. So moving forward, when you're talking about these debris mitigation plans and you need to address this in your applications, your license applications. So we're not talking launch vehicles. We're not talking launch licenses. We're not talking spaceports. If you have a satellite that you want to launch, you need to be aware of these new orbital debris mitigation rules. And you need to be aware of the debris assessment software, because you're going to need to run some simulations through. Additional supporting materials should be reviewed at the United States government orbital debris mitigation standard practices. NASA has had these for a long time. Again, I'm not going to get into the history from 2000, about 18 prior, other than what I mentioned. But there was some throwing some regulations out. The FCC had said, hey, NASA, military, DOD, Department of Defense, you've got some rules coming out on debris. Should we kind of apply those to the people that we regulate? Don't worry about it. No, we don't think you should do that right now. And so the FCC really piecemeal started to address it. Like if a new spectrum came up in terms of frequency, they might look at it briefly, but there was not a wholesale application of the rules or examination until really 2018 is when that started. So again, the Orbital Debris Mitigation Standard Practices update, the NASA procedural requirements for limiting orbital debris are some guidelines. Now, the FCC updated rules. We have the CFR. USC means United States Code. CFR means the Code of Federal Regulations. The statutes, United States Code, that's the statute. Statutes are above regulations. So treaties, Constitution, U.S. statutes, U.S. regulations, and then you get into state law. So Code of Federal Regulation is obviously federal, the United States. There are three main components: experimental radio service. I'm not going to address that today. Satellite communications, we will look at, and amateur radio service. And of course, like the FAA regulating everything in the airspace, the FCC basically regulates any telecommunications, any satellite communications, anything going through radio waves, your high school radio station, FCC license. I was told when I got my FCC license back in I'm dating myself, but about 1984, 85 is when I obtained my FCC license so that I could legally talk on the radio and was a disc jockey and engineer. I was told that they didn't expire, but I think that that was not accurate. I don't think that my FCC license from high school is valid anymore. So I'm still trying to explore that. But nonetheless, FCC regulates anything going through the airwaves. FAA airspace, FCC airwaves. So let's look at the section on satellites. Here are some of the changes. I'm going to fly through them because this is not enough time to go through and have a course on these regulations, but I want to give you an idea where things are headed and some of the new rules. So a licensee, now when we talk about a licensee, this is the party, the satellite operator or the party that's wanting to operate the satellite, to use the satellite. So the licensee shall ensure that the licensed facilities are properly secured against unauthorized access or use whenever an operator is not present at the transmitter. For space station operations, this includes securing satellite commands against unauthorized access and use. So this is talking about facilities on ground communicating with the satellite and making sure that we've got unauthorized access prevented. Again, remember, cybersecurity is key too. Orbit raising maneuvers. The space station operator will coordinate on an operator-to-operator basis with any potentially affected satellite networks. When you complete the application, you're going to need to provide a description of the design and operational strategies that will be used to mitigate orbital debris, including the following information. A statement that the space station operator has assessed and limited the amount of debris released in a planned manner during normal operations. It must indicate whether the space station operator has assessed and limited the probability that the space stations will become a source of debris by collision with small debris or meteoroids that would cause loss of control and prevent disposal, including whether this probability for an individual space station is 0.01, 1 in 100 or less, as calculated using the NASA debris assessment software or higher fidelity assessment tool. So I mentioned that software before. I wasn't kidding. Yes, you've got to use it. So you've got to show that the probability of an individual space station colliding with small debris or meteoroids would be 1 in 100 or less. That the space station operator has assessed and limited the probability during and after completion of mission operations of accidental explosions or release of liquids that will persist in droplet form. Again, talking about fuel, perhaps. Demonstration that the debris generation will not result from the conversion of energy sources, chemical, pressure, and kinetic onboard the spacecraft into energy that fragments the spacecraft. Also need to address whether stored energy will be removed at the spacecraft's end of life by depleting residual fuel and leaving all fuel line valves open, venting any pressurized system, leaving all batteries in a permanent discharge state, and removing any remaining source of stored energy, or through other equivalent procedures specifically disclosed in the application. A statement that the space station has assessed and limited the probability of the space stations becoming a source of debris by collisions with larger debris or other operational space stations. Where it's an NGSO, additional information is required. And that is a demonstration that the space station operator has assessed and limited the probability of collision between any space station of the system and other larger objects 10 centimeters or larger in diameter during the total orbital lifetime of the space station, including any deorbit phases to less than 1 in 1,000. I could go on and on and on and on. Like here, where requested geostationary orbit location, an assessment of whether there are any known satellites located at or reasonably expected to be located at the requested orbital location or assigned in the vicinity of that location, such that the station keeping volumes of the respective satellites might overlap or touch. Addressing the trackability of the space stations. Disclosing planned proximity operations, if any, and addressing debris generation that will or may result from the proposed operations. Detailing disposal plans for the space station, including the quantity of fuel, if any, that will be reserved for disposal maneuvers. In addition, they have even more specific provisions depending on the operations of the particular satellites. I could give an entire course on these new FCC updated rules. And I know one law student out there that might be interested in taking that course, but we don't have the time for this. But they do talk about geostationary satellite term extensions. I talked about my license, my FCC license, not to operate a satellite, but to speak on the radio as a disc jockey. There are license terms and renewals, so you need to be aware of the license terms and then the ability to get an extension. So if the license for 15 years, you can apply for extensions in 5-year increments. The application must include the requested duration, the total remaining lifetime of the space station, any single points of failure that could affect end-of-life procedures, the remaining fuel sufficient for planned deorbit, telemetry, tracking, command links, functional, so an indication that that's the case. Now, one of the great things that the FCC has done, though, it's implemented among these regulations other regulations that allow for streamlined small space stations to become operational and to get licensed. So this requires certification that the space stations will operate in non-geostationary orbit, have a total in-orbit lifetime of 6 years or less, be deployed at an orbital altitude of 6 kilometers or below, or maintain a propulsion system and have the ability to make collision avoidance and deorbit maneuvers using the propulsion, and be identifiable by a unique signal-based telemetry marker. As you can see, to facilitate compliance with these regulations, not only do you need, I would argue, a lawyer, but we need an engineer. We need a team to make sure that these happen to be complied with properly. Even within the streamlined small space station, you're still going to need the same kind of certification, some of which we reviewed before, that there's not going to be operational debris released, that you've considered the various things that are about collision, the going through the software, provide information relating to the description of the facilities, operation, and services, public interest considerations in support of any grant, a description of the means by which the requested spectrum could be shared with both current and future operators. Again, FCC is talking spectrum. It's the radio spectrum where you communicate, what frequencies and so forth. So there are a number of continued regulations, even within these streamlined small space station aspects, that we need to be aware of. In this, we also have that the space station operator or the licensee must provide, upon receipt of a space situational awareness conjunction warning, that the operator will review and take all possible steps to assess the collision risk and mitigate the collision risk if necessary. As appropriate, must take steps to assess and mitigate the collision risk, or they should include but are not limited to contacting the operator of any spacecraft involved in such a warning, sharing ephemeris data and other appropriate operational information with any operator, and modifying space station attitude and operations. As Commissioner, I am not going to pronounce her name right, as one of the FCC commissioners indicated, She would have liked the rules to tighten the 25-year rule that I talked before about from end of life to complete disposal. Talk about a focus on the deorbiting of end-of-life satellites, and address collision risks for large constellations. Think Starlink. Now, the further proposed rulemaking began to address some of those issues, and that was issued, and that's where the comments and reply comments were sought and obtained. So we're kind of waiting now for the final rulemaking in that regard. But those do address and are wanting further comment on the probability of accidental explosions. The existing rule requires merely a statement indicating that the space station operator has assessed and limited the possibility of explosion. So it's really just a statement that you've done that. The proposed would be that the operator must include a demonstration concerning limiting the risk, including a 0.001 metric, and updated the U.S. government. I mentioned earlier these mitigation standard practices. And so the FCC sought comments on how to assess the demonstration that this could occur in light of the ODMSP commonly accepted engineering and probability assessment methods and costs and benefits of such inclusion. So they're trying to address all these metrics and address all of these regulations. With large constellations, one of the issues is 0.001 enough? Some suggest that it should be per satellite. Some should be on a system-wide basis. So if you've got 1,000 satellites, that's actually reducing the probability or making it stricter, that it can be 1 in 1,000 of all of those particular satellites and so forth, rather than 1 in 1,000 chance on one particular satellite. Lots of questions existed, and there were many requests for comments. There another one, for example, should the commission adopt requirement that all satellites above a certain threshold have propulsion capabilities? There was a discussion of where that would be. 25-year post-mission, some suggest lower 5 years, unless a demonstration needed for more. All of these, there were indemnification discussions on indemnifying the United States, because remember, right now under the treaties, who's responsible ultimately? If there's a collision with a United States satellite, let's say a SpaceX satellite collides with a satellite from Japan, who's responsible under the treaties? The United States government is responsible for the operations of parties under its jurisdiction, the launching state rather. Now, what's interesting is if a satellite operator launches from another country, that's a different launching state. But the United States is also seeking possibility of indemnification. Interestingly, Boeing argues that there should be other means to secure funds from the operator. The FCC sought comment. Some suggested specific insurance. Some talked about bond requirements. These are all things that will be coming up, and the opportunity for comment and reply comment has elapsed. However, there are companies still battling it back in terms of their filings. Now, before I get to the end here, I know my time's running out, but I hope that I've kept your attention thus far, because I want to show you how easy it is to search for these things, and you too can file comments or reply comments. So the fcc.gov/ECFS. If you go to regulations.gov, you'll be able to find any kind of regulations. You'll be able to submit comments for most agencies, but the FCC has its own portal, fcc.gov/ECFS. And here it is. So we could put in, let's say we want to search for filings. We put in a specific text, and let's say we search for orbital debris. So we've got the website. We go to the top, search for filings. I'm just enlarging these things. We put in where it says search full text, orbital debris. We come up with a list of filings that are related to orbital debris. We see the docket number over on the right, 18313. You see the list of docket numbers there on the right. Here it is again highlighted. And we can dive into the specific documents even. So you could click on a particular document if you wanted to, or you could click on the, like where it says International Bureau, the top. So you see the FCC, right there, I'm showing you the document. Above that, you see International Bureau that also has a hyperlink. So if we click on that, the International Bureau, it lists all the documents right on the left-hand side. You see over on the right, the docket number again, the law firm filing is the FCC. You do not need to be a law firm or a lawyer to file anything with the FCC. This is the big docket number. This is the report and order and further notice of proposed rulemaking that came out last April 24th, 2020, docket number 18313. And you could find all the statements from the various commissioners. Now, what if you wanted to submit a filing? Same website, same title page. We just click over, rather than filings and proceedings for a search right over here, we're going to click submit a filing. And then again, we can search for filings without much difficulty. We put in the docket number that we found before, 18313. Right at the top, it self-populates mitigation of orbital debris in the new space age. Then we can go to submit a filing, or this is the same page, right? We're just enlarging it. That's the docket that I want. It puts in the proceeding. I can put in the name of the filer, might be me. Law firm is not required. Attorney, author's name, that's me as an attorney, or use the author, etc. You'd fill out the information that you could. Here is regulations.gov, as I mentioned. You could also search for there, and you'd find the same document. But again, for the FCC, you can't file through regulations.gov right now. You've got to go to fcc.gov/ECFS. But you can, on regulations.gov, look up the regulations, search as we've shown, search where the comments are due, the newest, the oldest, look at it and see what's going on. If it interests you, then you might pull up that you want to put in particular comments. But here you see again, the FCC, this was one of the follow-up rulemaking on information collection. Basically, what is the information burden for these regulations? You see that you cannot file here to direct all comments to Kathy Williams, FCC, by email. And there you go. But if we wanted to file a comment through regulations.gov, it's really as simple as searching for the particular comments. Now, over on the right, you'll see where you could even see which ones are commenting. So if somebody was obsessed with it and just wanted to file comments, they could go over and find what's coming up in the next few days. Look, enlarge it, click comment, put in your comment or drop a file, and you're done. You'd put the email address, that's it. Regulations.gov makes it very easy to submit comments. So where do we go? Next steps, I definitely recommend that we all actively engage in this process. We need to push the technology to improve situations with orbital or space debris. We need to develop new technologies. One example is the ED orbit, now clear space. Keep in mind ownership of space debris. That's another topic we don't have anywhere to get to right now. Space debris clear space scheduled for 2025. Active removal can be efficient. We need to target items to be removed by focusing on those with high mass, high collision probabilities, and high altitudes that have a longer orbital lifetime of the resulting fragments. Now, just a couple more points that Dave will bear with me here. One of the things that I'm passionate about, as I mentioned before, in May of 2019, satellites streaked across the night sky. You may have seen it. This is the Starlink satellites. There have been a lot since. This is my photograph. It's not pretty or anything. I was out trying to actually do some astrophotography, and I looked up and I saw them going across the sky, and I ran in to get my kids and my wife to come out and see what I had been talking about for months. And then I just quickly tried to grab this, which was on a much longer exposure time, hence the streaks. But these are some other, this is almost artwork, but I think to some astronomers it would still be a problem. So where do we go? How do we address that? Well, I've got to give SpaceX credit because they have worked with the astronomy community to try to develop technology. Now, somebody may have heard of Elon Musk's initial statement dismissing it. he's come straight to the fore and had his team focused with astronomers and looking at trying to come up with a particular solution. The first of which was DarkSat. That really didn't work all that well, and if we all know, we have dark leather interiors on our car. Dark absorbs the heat and the sunlight much more than light does, and so the DarkSat really didn't work all that well because it was heating the satellite. So they came up with VisorSat, which now every Starlink satellite launch has VisorSat on it, and it's developed to mitigate those solar reflectivity concerns. There's been public policy debates on this and discussion. SatCon 1 through the AAS, American Astronomical Society, and other parties. The Dark and Quiet Skies Conference for Science and Society through UNUSA. SatCon 2's coming up this year. Again, how do we do this? Where do we go? Actively engage, participate, work on developing policies. We all need to participate in the development of the future of our space and Earth's orbital environment. So I want to encourage you all to do that. I want to encourage you all to pay attention to the different regulatory agencies that are out there and each of the parties that may be involved. And with that, I open it up for discussion and see if there are any questions. And if not, before I forget, here's my contact information. You can also, an easier email address to remember for me is charles@mudlaw.com. charles@mudlaw.com. I thank my team for the help that they provided in getting some information put here. The background photo, if you can see that, is another one of my attempts at astrophotography. Finally, with this, I'm going to turn it over to Dave, and he can guide us through the last two slides, and then happy to address any questions that anyone might have.
Thanks, Charles. I really appreciate the discussion on this very important topic. And as someone who is delivering satellites, I've found this actually to be extremely useful. So before we get into well, maybe we'll just step through these things and then we can discuss slides, discuss questions. So I just want to let everyone know about our upcoming events. On May 18th, next month, we will have a presentation from Daniel Faber, the CEO of OrbitFab. OrbitFab is one of the up-and-coming on-orbit servicing companies. They plan to provide gas stations in space. So really looking forward to that presentation. Then on June 15th will be our final speaker event for the winter and spring session. We'll take a break for the summer following that. The speaker is not been determined yet, but I have some really interesting potential speakers for that one. But before those speaker events happen in May and June, I want to mention the Student Space Congress, which is coming up on April 29th and 30th. So that's happening very soon. And this is a virtual forum for students to present space-related projects, research, and work to a broad public and industry-specific audience. You don't have to be an engineer. You don't need to be building CubeSats. We're really interested in any sort of student work that is related to space in some way. So it could be space policy, it could be space law, it could be space economics, or it could be CubeSats. So really looking forward to what you have, what the opportunities might be there. This is, the registration for this is available on the New Space Chicago website. So please go check that out.
And Dave, before we get to I do see some comments here in the chat. I was focused on the Q&A, but I do see some chat comments. If you don't mind, I'll try to address a couple of them.
Sure. Well, I had suggested that we might do the questions before these two slides, but we can address those now. So let me ask you the questions, and then you can respond.
All
so
right.
in the chat, there was a question. How does the international community deal with events such as the 2000 Chinese ASAT test? And this event, although a show of force, did cause an increase in orbital debris by 25% and rapidly accelerates the potential of the Kessler syndrome happening. I would like to point out in one of your diagrams, you showed the amount of orbital debris that has been increasing over time. And in about 2007, there was a huge jump in the orbital debris. So that is an indication of the effect of these kinds of events. But so the question is, how does the international community deal with these kinds of events?
It's a really good question, and Dave, I want to apologize for mixing up on the order of things on the end here, but in the way that we address things. But I would say that unfortunately, unless there's a treaty that really addresses this head on, there's no, and then you need each country to sign on to the treaty. So for example, the Moon Agreement is a United Nations space treaty, but it has less than 20 parties that have signed on to it, and most of the countries in the world don't have to abide by it because they haven't agreed to it. And the one particular aspect, I'll just make it as an aside, the one particular aspect that the United States and Luxembourg have disagreed with, and both disagreed and enacted laws contrary to, relates to the ownership of items from the particular space objects. So that, for example, I wasn't finding the words that I wanted. So for example, if we go to the moon and we pick up some regolith or some moon rocks and so forth, the Moon Agreement says that there is no private ownership of those items. The Outer Space Treaty already says nobody can own the moon. Nobody can own, like, plant a flag and say, this is the United States base, we own this. But it was kind of arguably silent on specific pieces of a planet or an asteroid or a celestial object, I guess that's the term that I was looking for. So the Moon Agreement expands further and basically says that anything from any celestial object cannot be privately owned. The United States and Luxembourg, you might ask why Luxembourg, that's SES, but they've enacted laws that say, oh, yeah, we can. But in answer to your question, we really need to have the support, the international community organizations, the IADC, support the United Nations in dealing with orbital or space debris and kind of pushing through beyond just guidelines, the mechanism to ensure that countries are operating in a safe and responsible manner. There could be an argument right now that, for example, if there's, whether it's China or India launching ASAC technology and the debris from that collides with my satellite or United States satellite or the, let's say the US side of the ISS, there's an argument under the treaties right now that the launching state would be liable for that in a jurisdictional and kind of liability perspective. But in terms of trying to get countries to refrain from that bad conduct, it's really putting pressure on getting something stronger than guidelines. Each country should implement their regulations to make sure that that happens. The international community is aware of these issues and has been dealing with them since 1993, but in terms of getting to a point where there's any enforcement, there's no real enforcement right now. So it's encouraging good practice, being a leader. The United States needs to be a leader in that. Russia needs to be a leader in that. China now needs to be a leader in that. But from our perspective in the United States, we really need to step up the bar, implement regulations, and practice what we preach. And then hopefully others will follow.
So I have kind of a follow-on question to that. In one of your slides, you mentioned something about needing to license or to describe to the FCC if you were going to perform remote proximity operations, or in other words, approach and dock with or rendezvous with another spacecraft or satellite in space. I wonder how cumbersome, it's not quite the word I'm looking for, but or practical are these regulations, as we're starting to see a significant increase in small companies really that are developing technologies to perform on-orbit satellite servicing, which will require maneuvering to close proximity with another spacecraft and then potentially performing operations on that, which admittedly could result in orbital debris. Hopefully not, but it is a potential scenario. And so, those activities are just going to continue to increase with time. And so, is there any provision for those things being made in these new regulations that are coming down the pipeline, or is that something that still has to be dealt with in more detail?
I think that a little bit or a lot of both and everything. I mean, I think that what you began with, the concern on the burden of these regulations, specifically on smaller companies, is real and is a concern. And I think that you have the larger companies, SpaceX, Viasat. They have a team of lawyers watching the regulatory space all the time. I mean, when I was saying that companies are still going back and forth in the regulations, even though the comment period's closed on the further notice of proposed rulemaking, SpaceX and Viasat are going back and forth, responding to one another and basically arguing with one another through the regulatory process. The larger companies have a team of lawyers looking at this all the time, and they are filing comments, and they are getting in the space where the regulators might see it. I think that it's essential, Dave, that the smaller satellite companies, the smaller companies, either individually or collectively come together and have a group focused on filing comments and advocating their concerns. Not only is the burdensome aspect of the regulations, like, one, I mean, it's not just a burden in terms of the written word, right? And filling out the paperwork and everything. It's burdensome and perhaps technologically difficult for a small company to do the engineering and the testing to provide the metrics and information that the FCC might want. For example, it wasn't regulatory required, but look at what SpaceX did with the astronomy community, which again, I applaud. I think it's fantastic. Your small company would not have been able to invest the technology to just find a solution that might work to appease a particular other space interested community. Now, hopefully SpaceX will share some of the technology, which have been, which there were indications that it intended to share some. So I share your concerns. Another point on the burden facing small satellite companies is the bond requirement. What basically that means is that a company, before they launch a satellite, would have to put up a bond as security against the potential collision or creation of debris of their object, their space station would create. Let me rephrase. The bond is insurance against the company space station causing a collision or causing liability to a third party of the United States. So the bond is kind of your security deposit. Now, some companies are going to be able to easily afford that. It might end up being completely cost prohibitive for small companies, even with the streamlined regulations that the FCC has also adopted. So I guess I share your concerns, and I think we need to watch this space, to quote another commentator, and see what happens. But it is a concern, and I definitely think that we, particularly the new space community, not just New Space Chicago, but those involved in the smaller companies, the new space companies starting up, we need to make sure that the FCC hears those voices so that we'll get those questions addressed and the regulations in a way that allows the technology to move forward. Because I agree with you, and the last point I'll make, these companies are developing great technology, innovative things, and we don't want to inhibit that. We don't want to deter that. We want to encourage it. We all want to do it in a safe way, and I think a balance can be reached. I hope that answers your question.
One comment to your point about industry organizations. There are in fact, some industry organizations ranging from the Commercial Spaceflight Federation and the Small Satellite Alliance and so forth. But specifically with respect to on-orbit servicing, there is an industry organization called CONFERS. And I can't remember what the acronym stands for, but they are specifically focused on policy issues around on-orbit servicing.
Okay, great.
So I assume they're addressing some of these issues.
Yeah,
another
in
question.
fact, I'm glad that you mentioned CONFERS because it's a great organization, and you're completely right. I was remiss not mentioning those, but we need to encourage them to continue and pay attention and participate in the comment process. Sorry, go ahead.
We have another question relating to the anti-satellite weapons demonstrations, and that is, what actually constitutes an attack, and does that justify military intervention?
Well, technically, I'm not. Let me answer it this way, that whether an object, right now even, whether an object is space debris or not, it is still owned by the party that owned it from the beginning, and the launching state, the country rather, that launched that object is still the launching state and has responsibility for it. So what does that mean? That means that any technology being developed to go up and grab space debris and bring it down, or do something with it, you might be able to do something to your own, but unless you have permission to collect or do anything with somebody else's space station or space debris, you're going to run into a significant issue because you're interfering with somebody else's property. There's a whole aspect of that, and I've done a presentation on the laws of the seas equivalent in that regard, but essentially any space debris is still owned by the party that launched the original object, whether it's pieces or whether it's a whole object. So if you do something to that, whether that's collecting or in an ASAT aspect, intentional or there's just a collision, you're going to have a liability issue. When does it become an attack? I would say that, I guess it depends on one's definition of attack, but I would say that any effort to harm another country's or another company's object in space, intentional, is an attack. If it's negligent, if it's wasn't intended but it happened and there was a collision, I wouldn't so much call that as an attack as just perhaps a collision. But that is something where I'm probably not the party to answer so much, and I'm not inviting somebody that's in the audience to necessarily step in and answer this question, but I will refer to an agency that I was remiss in not mentioning before, and that's the United States Space Force, and they probably are in a better position to respond and answer that agency and as to what an attack is or not. But I think it would be the individual launching state, the country, making a determination when an attack happens to be. Like the India example, that the simulation that I had, and I appreciate the China reference from 2007, but the simulation that I provided, I mean, that was them destroying their own satellite, India. So that wasn't an attack because it was them doing it to their own. Irresponsible, I would argue, and should not have happened, but an attack it was not.
Just riffing off this general topic, I am a fan of various science fiction movies that depict space battles of one kind or another, and also various science fiction literature. And something that's never addressed in any of those things is the resulting space debris that would be produced by blowing up other spaceships. And as we've been discussing the issue of orbital debris, and it's become more and more of a problem, just sort of the exciting aspect of space battles and whatever becomes actually very frightening when you realize the result of that, whether or not you end up killing the enemy spacecraft, is going to be massive debris that will cause hindrance to navigation for a long time in the future.
Right.
And which to my mind seems to be I can't think of the word I want to say, dissuasion, but a reason not to engage in space battles.
Yeah,
deterrent. There you go. That's
deterrent, right?
Great. Do we have any other questions?
Let's see.
There were a few comments in the chat, but I think we've covered all of those questions, and I'm not seeing any in the Q&A. Great.
If anybody wants to chat with me offline or at the next New Space Chicago event, grab a table, I'd be happy to participate. You can again reach me at charles@mudlaw.com. And I appreciate, Dave, as always, the opportunity to speak in front of New Space Chicago and the community, the great people that we have. So thank you.
And thanks to you, Charles, for this enlightening discussion. Really appreciate it. Can we go to the next slide?
Absolutely.
So I've already mentioned the upcoming events, and I would just like to finish by reminding everybody that New Space Chicago is a 501c3 nonprofit organization. We do run on donations, and so we appreciate any contributions to the cause. If you are an organization or potentially even an individual, you can become a New Space Chicago sponsor. We have two sponsorship levels. The event sponsor is $250 per event, and your logo and other potential information about your organization will be presented during the presentation. Or you can be a premier sponsor at the low rate of $1,500 a year, and then your logo and other information will be listed on the New Space Chicago website and displayed during all of our events. So really appreciate all your support. And so with that, I think we can end the presentation for this evening. I will put us back into the networking floor. And so if you desire to hang around and continue the conversation, you're certainly welcome to do so.